Are you trying to figure out how to plan your estate in a way that benefits your blended family? Nowadays, the picture of a modern family is not as typical as it used to be. Mom, dad, 2.2 kids, and a white picket fence. Today, it is gladly accepted that families come in many configurations, which are all beautiful, but may pose more challenges in estate planning. Let's consider the blended family as two spouses that bring children from previous marriages together, thus creating a joy that is so unique. For the testators, meaning mom and dad, who brought their children together, estate planning tends to be the time where they need to take a step back and consider asset protections for their biological children. Now, the Ontario Family Law Act states that marriage is an equal partnership where both spouses have the rights to 50% of all assets accumulated during marriage, even if one spouse dies and regardless of what that dead spouse's will indicates. That being said, for testators in blended families, this can cause a fair amount of consternation. Let's consider a made-up scenario of Daniel and Sandra. These two have been married for 10 years. Daniel has 2 children from his previous marriage, and so does Sandra, making a total of 4 kids. At the time of marriage, Daniel had $350,000 in assets, while Sandra only had $50,000. But when purchasing their home, each contributed $50,000 towards the purchase. Now, over the course of their marriage, the couple has accumulated $800,000 in assets, with the lion's share of $600,000 coming from a business started and operated by Sandra. Now, Sandra has always thought that through her business, she would be in a position to leave her 2 children with exclusive inheritance that would be significantly more than what her spouse, Daniel, could leave to his children. Now, is she mistaken in her thinking? The short answer is yes, unless Sandra were to take estate planning steps beyond simply getting a will drafted and implemented. In the case where she predeceases Daniel, she could leave the $600,000 to her children, but Daniel can legally ignore the will and take hold of that amount because it was accumulated over the course of their marriage and fits into that equal economic partnership. But if we consider the opposite, where Daniel were to predecease her, she wouldn't be able to take half of his $300,000 because it was accumulated prior to their marriage. Now, to further complicate matters, in Ontario, a marriage revokes a will. So if Sandra and Daniel both have wills leaving everything first to one another and then to their children equally after the last of the 2 of them dies, and let's say that Sandra dies and Daniel remarries again, his will is revoked. If he doesn't execute a new will, he would die intestate. This means that the law uses a fixed formula to determine who gets his assets, including the assets intended by Sandra for their children. That formula would see that Daniel's new surviving wife and any children they have together would get those assets, which is very far from what Sandra initially intended. So what can you do? There are a few things that you can consider when planning your estate, but the first option would be to simply talk about it. There is no substitute for a good, honest, and open conversation. And besides, talking to a professional and good estate planning lawyer will help you get the facts, the law, and your options straight. The second recommendation I can provide is don't be afraid of marriage contracts. While marriage contracts may be seen as a lack of faith in your spouse or marriage, they are often simply indicative of a settled intention to put the interest of the children above all considerations. The third recommendation is don't be intimidated by trust. Yes, we've all heard the phrases trust fund baby, which gives us the image of an ultra-rich parents born with silver spoons in their mouths. But in truth, trust can be useful to everyone and, for instance, can be funded through insurance proceeds or gains from the sale of a real estate. And the last recommendation is keep your designation in the game. To clarify this, remember when setting up your RSP and the banker asked who you would like to receive the funds should you pass? This could include any assets that you hold in RSPs, TFSAs, LRIAs, and so on. These contractual assets don't have to be bequeathed through a will. A simple designation does the trick, meaning that if you pass, the bank will simply follow the instructions in the designation, and the funds will end up with whomever you want. Being part of a blended family can make estate planning more difficult than it needs to be, but hopefully this video has cleared up some of the misconceptions and confusions that may be crossing your mind. If you are in the process of planning your estate or simply looking for more information on what you can do to protect your estate, contact us at afolabi.law where a professional can help assist you.